The 17th Constitutional Amendment Act 1965 placed 44 state enactments under Schedule 9 of the Constitution, making them immune from challenge before the constitutional courts. It also validated certain acts which were declared ultra-virus by the Supreme Court of India from 1955 to 1964, making them immune and also nullifying the judgments of the Supreme Court declaring them to be unconstitutional. Certain petitions were filed before the Supreme Court challenging the validity of the 17th Constitutional Amendment Act. The question was with regard to the scope and ambit of Article 368 as it then stood, which provided for the procedure for the amendment of the Constitution. Article 368, which lays down the procedure for amendment of the Constitution, provides that an amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either House of Parliament, and when the bill is passed in each House by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting, it shall be presented to the President for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. Provided that if such amendment seeks to make any change in A to E, the amendment shall also require to be ratified by the legislatures of not less than 1/2 of the states by resolution to that effect passed by those legislatures before the bill making provision for such amendment is presented to the President for assent. So Article 368 provided for the procedure for the amendment to the Constitution, and it had a twofold requirement of having the majority of each House and also the 2/3 majority present and voting. If the amendment was to be made to any of the provisions prescribed in the proviso to Article 368, it required the ratification by the legislature of at least half of the states by resolution to that effect. Article 226 fell within the proviso to Article 368, and therefore if an amendment was to be made in Article 226, it required the ratification of the state legislatures of at least 50% of the states in the country. The main contention of the petitioners before the Supreme Court in this matter was that since the judicial review of high courts is taken away under Article 226, as the acts have been placed under Schedule 9 of the Constitution, the Article 226 stands amended and altered, and therefore it required the ratification of 50% of the state legislatures, which was not done, and therefore the constitutional amendment was invalid. The three judges of the Supreme Court, in its majority judgment, held that this requirement was not necessary in accordance with the principle of pith and substance. The Supreme Court held that in dealing with constitutional questions of this character, courts generally adopt a test which is described as a pith and substance test. That in such an inquiry, the courts must ascertain the true nature and character of the enactment, its pith and substance, and it is the result of this investigation, not the form alone, which the statute may have assumed under the hand of the draftsman, that will determine within which of the categories of subject matters the legislation falls. And for this purpose, the legislation must be scrutinized in its entirety. The Supreme Court applied this pith and substance test to the amendment made to the Constitution and held that the Article 226 did not stand amendment and there was no change in Article 226, and therefore the requirement of ratification by 50% of the states was not required, and therefore this contention was thereby rejected. It was argued that the constitutional amendment, which placed 44 enactments which included certain acts which were declared to be ultra-virus by the Constitution, was not within the purview of the constitutional amendment and it was invalid. With respect to this contention, the Supreme Court held that the power of the Parliament to make laws prospective and retrospective was within its purview and ambit, and the constitutional amendment could also be made retrospective, and therefore validating certain acts which were declared to be unconstitutional was within the purview of the Parliament and therefore rejected this contention. The next argument, which was made by the petitioners, was that the Constitution does not provide the power to the Parliament to amend Part 3 of the Constitution of India. With respect to this argument, the three judges of the Supreme Court held that the power and the procedure prescribed under Article 368 is of very wide nature, and it provides for the amendment of any part of the Constitution, which includes Part 3. And therefore, relying upon the judgment of the Supreme Court in the matter of Shankari Prasad, it held that no different view was required to be taken, as that was the correct view, and the definition of law as provided in Article 13 does not include the constitutional amendment, and therefore Part 3 of the Constitution could also be amended. This judgment is important because two judges of the Supreme Court at that time took a different view with respect to the view taken by the majority. Justice Hidayatullah and Justice Mudolkar questioned the correctness of the judgment of Shankari Prasad and also raised some doubts with regards to the correctness of the question of law involved in the matter. Justice Hidayatullah was of the view that there are certain aspects to the Constitution which are permanent. Justice Hidayatullah was of the view that certain parts of the Constitution have the effect of permanency. He questioned that to what extent the Constitution can be amended. He was of the opinion that there are indications in the Constitution which need to be reconsidered, and the view taken in Shankari Prasad might not be the correct view. He laid emphasis on the word law as provided in Article 13 and held that the definition of law in Article 13 is wide and all-inclusive and does not provide that it excludes the constitutional amendment. He was of the view that if the framers of the Constitution wanted to exclude the constitutional amendment from the definition of law, they could have provided a proviso in Article 13 which prescribed that the definition of law would not include the constitutional amendment. He said that the Constitution gives so many assurances in Part 3 that it would be difficult to think that they were the playthings of a special majority. To hold this would mean prima facie that the most solemn parts of our Constitution stand on the same footing as other provisions and even on a less firm ground than that on which the articles mentioned in the proviso stand. The anomaly that Article 226 should be somewhat protected but not Article 32 must give us pause. I can only say that the power to make amendments ought not ordinarily to be a means of escape from absolute constitutional restrictions. Justice Mudolkar was also of the view that the judgment of Shankari Prasad needs to be revisited. Justice Mudolkar, in his opinion, said, the Constitution indicates three modes of amendment, and assuming that the provision of Article 368 confer power on Parliament to amend the Constitution, it will still have to be considered whether, as long as the preamble stands unamended, that power can be exercised with respect to any of the basic features of the Constitution. To illustrate my point, as long as the words sovereign democratic republic are there, could the Constitution be amended so as to depart from the democratic form of government or its republic character? If that cannot be done, then as long as the words justice, social, economic and political are there, could any of the rights enumerated in Article 14 to 19, 21, 25 and 31 and 32 be taken away? If they cannot, it will be for consideration whether they can be modified. So the concept of basic structure was developed from the minority view of Justice Mudolkar in this judgment. The Supreme Court for the first time realized that there are some basic features to the Constitution which should not be allowed to be amended. It is because of this minority view which was later on accepted to be a majority view in later judgments, which I will be dealing in other videos.